Hi, this is Lizzie Mahacek and Hazelnut, my sidekick. I am acting as a juror for the courtroom drama case of the plaintiff Cook suing the defendant Ashford Hospital for the improper release of her health information, which is alleged to be protected under the Privacy Act. From my research and understanding of the case, the plaintiff's personal health information, or PHI, was distributed in an email to fellow employees on the operating room team, as well as a supervisor at Ashford Hospital. The plaintiff was not only an employee at the hospital, but also a patient with an upcoming scheduled surgery at Ashford Hospital. So without knowing what kind of consent the plaintiff signed, or if she requested any restrictions to her PHI distribution, it appears that the hospital was just following their normal procedures for all surgery patients. Unless she called out her supervisor as someone whom she didn't want to see her PHI, then it would be normal that her supervisor receive any information about an employee and or a surgery patient, as well as the operating team, which is what I took from the case write-up. Ashford Hospital is considered to be a covered entity by definition under the Health Insurance Portability and Accountability Act, or HIPAA, Section 160.103 of Title 45 Code of Federal Regulations. On the U.S. Department of Health and Human Services website, or hhs.gov, a covered entity has many exceptions regarding health information privacy and how it can handle disclosure. The area of consent states that individuals have a right to request restrictions on how a covered entity will use and disclose protected health information about them for purposes of treatment, payment, and healthcare operations. It then goes on to say that a covered entity is not required to agree to an individual's request for a restriction, but is bound by any restrictions to which it agrees. Now, the plaintiff is suing Ashford Hospital for financial retribution due to her claim of improper distribution of her PHI. However, the supervisor and other employees are protected under the HIPAA covered entity law, therefore legally have the right to see the plaintiff's PHI for treatment purposes, as translated from Section 164.506 of Title 45 Code of Regulations. In reading further into covered entities on the Health and Human Services website, it is stated that a covered entity has the option to obtain an individual's consent for treatment, but that it is not mandatory. So although I didn't feel that it was clear in this case whether or not the plaintiff had given written consent, due to her being scheduled for an upcoming surgery means that she gave consent in some form, which means that Ashford Hospital could distribute her personal health information according to their procedural regulations. So after researching this at length, I feel that the defendant, Ashford Hospital, is not liable to pay the plaintiff for any wrongdoing. I am voting in favor of the defendant, Ashford Hospital, and I look forward to hearing more about the case. Thanks, and good night.